Right, good morning and welcome to our LMC podcast with Louise Pinder, who's kindly agreed to speak to us about her work as the HM Senior Coroner for Rutland and North Leicestershire. Louise, I wonder if you could. Good morning. I wonder if you could introduce yourself and just sort of tell us a bit about your background and previous experience before you came into the role.
Okay. Well, I was appointed as the Senior Coroner in Rutland and North Leicestershire in August of last year, but I've been working as a coroner since 2005. So I was appointed in Derbyshire as what was called then the Deputy Coroner. I was approached by the then Senior Coroner, and it was before all the changes, which I'll tell you about if you're interested in due course, but it was all very relaxed in those days, and he contacted me because I had appeared before him as an advocate in his court and he was looking for a deputy, and I started to do that work part-time, but I pretty quickly became a full-time assistant coroner, as we're now called, or as they are now called. Worked in Derbyshire up until I was appointed in August of last year here to this full-time role, but also was appointed in North Leicestershire, Rutland and Nottinghamshire in 2018. There was a joint recruitment between the senior coroners in both jurisdictions, and there were quite a number of assistant coroners who were taken on during the course of that recruitment process. So I'm familiar with North Leicestershire and Rutland, but worked as an assistant coroner, as I say, until appointed last year as the senior coroner here. Taking over from the senior coroner who'd been here for many years.
Yes.
The role is full-time now. It was part-time under the previous senior coroner. And you will be aware, because we have discussions all the time, Grant, about the jurisdictional boundaries, that it's not a straightforward jurisdiction in terms of the boundaries. So the drive was it contemplated during the build up to the 2009 Act, which was a big piece of legislation for us and changed a lot of the way that we worked. There was a lot of talk, first of all, about a national coroner's service. And there was also talk that if that didn't happen, then the jurisdictions really should be county boundaries. So in Derbyshire, for example, when I joined, there were 3 jurisdictions, and eventually it was 1, and that was Derbyshire. And you'll be aware that in a lot of counties, they are now county boundary. But in Leicestershire, it remains the north and the south of the county are divided. I work very closely with the city coroner, who covers the south of the county as well. But they are entirely separate jurisdictions. And the boundary, unhelpfully, isn't straight across. If you've seen the map, you'll see it's a slightly strange, I think it actually follows the boundary of some of the borough council boundaries. As things stand at the moment, that it will remain that way, that there'll be 2 jurisdictions within Leicestershire, and I'm also the senior coroner for Rutland, so that sort of fit quite nicely geographically. But as I say, the discussion for a long time was whether there ought to be a national coroner's service, and I think that would be more helpful actually to everybody if there were. But I think one of the historical challenges, and now we're getting into politics, and I have no interest really in politics and have no real understanding of it, is that, of course, as things stand at the moment, my service, all the other coroner services in England and Wales are funded by the local authority. So in my case, Leicestershire County Council, the city coroner is funded in part by the city council and also by Leicestershire County Council. So it's complicated, and I suspect that central government decided that it would be too big a task and too expensive to take us on. So they left us with, locally funded. And it's quite a strange relationship, therefore, that we have, because although my office and the court, I know you know where we are, but for those that are listening, we're based in County Hall in Glenfield. My office is, my staff are all county council employees. As I say, we're funded by the county council, but I'm entirely independent of Leicestershire County Council and have to be because of some of the inquests that I deal with. Leicestershire County Council are interested parties, and there are questions are being asked about things that may or may not have done in the context of a death, and therefore I have to sit entirely independently. But can be a very difficult relationship between coroners and county councils, because this is where the money's coming from, but at the same time I have to ask sometimes some pretty difficult questions about deaths that have occurred where the county council are involved. So it's unusual in that respect. I've worked pretty closely with Professor Mason, who's the city coroner. I've known her all of my professional life, and the message really to everybody is that we try to be, whenever we can, consistent, because what we don't want is to cause confusion for those that are dealing with, you know, I mean, I can't give you the geography, I'm afraid, but, you know, there are certain roads in Leicestershire where number 15 is
Absolutely.
Professor Mason and number 18 is me. So it creates difficulties, particularly for GPs. And the other problem, of course, and I think we've had some discussion about this, actually in relation to some of our neighbours. So Nottinghamshire, it might be a Leicestershire postcode, but it's a Nottingham GP, or vice versa. But in terms of my jurisdiction, the law is very clear that if somebody dies and the body is lying within my jurisdiction, then the investigation is for me. Having said that, we have a good relationship as coroners locally. We do sometimes transfer investigations between coroners areas because it makes it more straightforward. If actually the GP is in Nottingham, you know, the family are all in Nottingham. If they've been into a Nottingham hospital, then it doesn't make a lot of sense for me to be investigating that death. So we would then request for the death to be transferred. But it can be quite difficult, I think, for you and your colleagues sometimes to be clear about which jurisdiction it is. Having said that, I wrote to everybody when I took over in August and sent a map, and I'm hoping everybody's got that pinned up on their wall. And if in doubt, you know, contact us and ask if it isn't within our jurisdiction. I mean, things have changed again because of the September regulation changes, which I'm sure we will talk about, because of course the first point of contact very often now is with the medical examiner, and the medical examiner will be very clear about the jurisdiction. So yeah, so that's my background. I was originally, before I became a coroner, I was a solicitor. So I qualified as a solicitor. I worked in private practice. I worked in-house doing corporate work, but advocacy really was the bulk of the work that I did, which is how I became involved in the coroner's service in Derbyshire way back in 2005. And now actually, you have to be a solicitor or a barrister. You have to be a lawyer to be a coroner. When I joined, you could be the medically or legally qualified, but they changed that. The 2009 Act changed all of that. So you will come across some medically qualified coroners, but they're now not many of them because most have retired, I think.
Yes, and that was my experience when I started, that most coroners I dealt with were medically qualified, or sometimes jointly qualified, medically and legally. I mean, it's interesting what you say about the jurisdictions. I mean, my practice actually straddles the border between the city and the county, and for other services as well. We're constantly having to think about, you know, where does the patient actually live, as to whether it's a county service or a city service. With regard to your letter and the map, just to remind sort of listeners that these are on the LMC website. So if you can't find it, if you want to, if you need to have a look at it, then please go to our website and it's on there. The other interesting thing that came to mind when he was talking about jurisdiction is that I used to do work in the House of Parliament from time to time, and I was chatting to a medical peer who was saying that they'd had a death of a peer in the House, at which point they were told that they weren't allowed to verify death in the House I don't know if this is still true, but at the time, any death in the house, actually, it's the reigning monarch that has to act as a coroner.
Oh, is that
so
right?
so they were told that they had to put the deceased into an ambulance and take him over the bridge to the hospital across the way, to have them verified in ED there, and definitely not within the palace, which I thought was quite funny at the time.
All the quirks of the English law, you
absolutely,
say.
yeah. But they make our days better at times. So just coming to that, I mean, from what would a normal day look like for you at work?
Well, we by comparison to a lot of jurisdictions are relatively small, and again, going back to what was contemplated before the 2009 Act, the idea was to make jurisdictions much bigger, and the sort of model jurisdiction would look like a senior coroner who's a full-time appointment. By the way, they're all lifelong appointments as well. So although we are appointed by the local authority, the chief coroner, who is London-based but is very involved nationally, also has a say in the appointment. Once I'm in post, then I'm not an employee, so it is a lifelong appointment. So senior coroner, who is full-time, supported by an area coroner. So these are all they're not new roles, but the wording changed. So I suppose an area coroner was the equivalent to what I was doing as a deputy coroner all those years ago, but now they are full-time appointments, and they support in a full-time capacity the senior coroner, and then a number of assistants who normally work part-time, and quite a lot of those assistants have other jobs. So there'll be lawyers who work in private practice or in NHS trust, but obviously not the local NHS trust because there would be a conflict, or as was the case with me, a full-time part-time assistant coroner who worked in a number of different jurisdictions. So that's what the model area looks like. But for my jurisdiction, because we're relatively small, I mean, we get just under 1,000 deaths reported a year compared to Derbyshire, Nottinghamshire, Staffordshire. That's a very small amount. I mean, we're doing, quite a lot of inquests, a few jury inquests a year, but most days actually I can do the work myself. So if I'm working as I am today and I'm the only coroner in the county, then I will, and have been before I came on to talk to you, be dealing with deaths that have been reported, coming in through the portal, because you know that all deaths, certainly from GPs, have to be reported through our portal. And again, that wasn't something that was decided locally. That's a national, that's now national guidance. Every jurisdiction is doing that. So new deaths that are coming in. So I will be looking at, if it's a death from a GP, I'll be looking at the GP referral. I'll be looking at whether or not they've spoken to the medical examiner. If they have, and they should have done, then I'll be saying what the medical examiner has said about the death, making a decision about whether or not we need a post-mortem examination, the type of post-mortem examination that we'll require, and moving the death on to that stage of the investigation. If I decide that it's not a death for us for whatever reason, and again, we can talk about the September regulation changes, but I can then, of course, return by way of a CM1A the death to the general practitioner, or in fact, I can send it back to the medical examiner to register the death. So that's the sort of first contact. I think what stakeholders perhaps forget, and I'm not criticising them for this, is that we deal with all manner of deaths. So whilst I'm dealing with a number of deaths this morning that have come from GPs, I might also be dealing with a murder. The police may have contacted me overnight and said that that there had been somebody killed in suspicious circumstances, somebody died in suspicious circumstances, and the coroner, obviously, I am always involved in those early stages. There may be queries coming in from funeral directors. Perhaps the death hasn't been reported, but they're raising concerns. So there can be all sorts of different stakeholders that are contacting us about all sorts of different types of death. But the first part of that, in every case, is to decide whether we've got a medical cause of death and whether or not we need a post-mortem examination. What I will do after I've finished speaking to you is to go into court. I've got a number of cases that are listed today, but they're straightforward cases. In fact, I don't think any of them today, the families are not coming. They've opted not to come to court. And so I'll be dealing with the end of the process, if you like. So the conclusion of the investigation, if it has had to go to inquest, I'll be dealing with those as well today. And then there's all the stuff in the middle as well. So there are cases that perhaps we have had a post-mortem examination. We now know the cause of death, and I've got to review it to decide whether or not we need to continue with an investigation, or in fact we can discontinue at that stage. I mean, GPs, you know, when they're reporting, certainly now that the medical examiner system is in place, if they're reporting the death to us, they're saying to us that the cause of death is unknown. That's why it's coming to us, or there are significant issues in relation to care. If when we've had a post-mortem examination, the cause of death, it's been confirmed by the pathologist that the cause of death is natural, then I have to make a decision at that stage whether or not there are any care concerns or whether I can discontinue. Because you'll know, Grant, that there, of course, the natural cause of death from a clinician's point of view is slightly different from a natural cause of death from a coroner's perspective, because I'm looking at the bigger picture. I'm not just looking at the clinical issues. So that's a normal day, really. And then on top of all of that, as a senior coroner, of course, we're actually managing. I mean, we have to be careful about using that phrase because I'm not really a manager. I mean, I'm an independent judicial officer. The staff that work for me, as I say, are appointed by and paid by the local authority. But they're my team, and you will know them, and they're a brilliant team. But they, you know, everything in terms of the running of the office, the running of the court, you know, managing the team also falls to the senior coroner. So it's incredibly varied. And the one thing I would say, and I suspect this is very similar to you and your colleagues, is that, you know, arriving in the office every morning, I never know what's, other than the cases that are listed for inquest, I never know what's going to come through the door. So it's all very, very reactive. And some days are pretty manageable and other days much less so, depending on what's coming in. So there's no typical day and there's no average day, but that's what makes the job so interesting, actually.
Absolutely, and that's why I'm a GP and don't work in the hospital, because I couldn't cope with doing the same thing day in, day out. A few times you've mentioned the September changes. Of course, that brought in the mandated requirement for GPs to use the ME service. I mean, it's sort of embedded now, but I mean, what do you think? Do you think it's working? Have you got any concerns about it? I know that there's been a few bumps that we've talked about along the way, but how do you think overall? Do you think it's improved the system? What's downsides to it? What's the upsides?
I think I'm really pleasantly surprised, actually, Grant, and I don't know how you feel about it, but we were quite nervous about how it was going to, you know, bed in. You will know that in a lot of jurisdictions, and certainly in the city, Leicester City, the medical examiners were already up and running. There have been a number of pilot schemes around the country, and there were medical examiners in quite a lot of the acute hospitals. But in the community, and of course I don't have any of the acute hospitals in my jurisdiction, so it was brand new, wasn't it, to all of us. And we were nervous about it. We thought it was going to be pretty significant. Unfortunately, or perhaps fortunately, depending on which way you look at it, I had booked a 2-week holiday, which covered that period before I was appointed as a senior coroner. And so whilst I was in Mallorca, I was sort of managing it and watching with interest as to how those first few weeks, how it all settled in. And I have to say, the 2 weeks that I was away, there were no problems at all, because I think it was so new. It was just taking time to work through the system. But pretty much as soon as I got back from my holiday, it became apparent that there were some issues, and we've talked at length with the various stakeholders about this. But I do feel now that it really has settled in, and I think GPs certainly seem to have got their heads around it. You know, it's a big change, isn't it? And I think you know, the sort of the principle is that there is, you know, there's a real distinction now between medical and legal certification of death. And I think what was happening historically, which I think was probably quite a good system for GPs, but not really very good for coroners, is that we were getting a lot of contact from GPs, whether it was formally in the form of a referral or informally, along the lines of, well, we're not really sure about the cause of death. What would you accept? Would you accept ischemic heart disease, or actually, do we need to focus more on the lung disease? And, we were happy to try and help as coroners, but actually we're not qualified. I mean, I have no legal, sorry, I do have lots of legal, I have no medical qualifications at all. And of course, having done the job for so many years, I know what a cause of death well formulated looks like, but I hadn't got any access to the notes. Sometimes I wasn't even able to talk to the GP directly about it. And we were being asked to, the phrase we all used to use is that we were covering the cause of death so that it could be registered. So basically the GPs were getting the stamp of approval from the coroner, for what it was worth, so that they could register the death. And I think that always sat very uncomfortably with me, because although I was happy to help GPs, what do I know? You're the experts, you know what the cause of death is. I don't know why GPs felt it was appropriate to come to me, except that was the system and they were looking for reassurance. Fine. But I think the system we've got now is much better, because when you go to the medical examiner, which you should do in respect of every death, and talk to the medical examiner, first of all, they're medically qualified. Secondly, they've got access to all the notes, including the hospital notes. So sometimes even stuff that you as a GP can't see, they can see that and help with the formulation of the cause of death. And long term, what it will mean is that as coroners, we are not being troubled, and you are not having to spend time contacting us in relation to causes of death which are entirely natural and shouldn't have been anywhere near us. Because if you go back to the legislation, and I don't want to be too law heavy, but you will know that the deaths that the coroner should be dealing with, in very broad terms, are natural causes of death, or deaths that occur in state detention, whether natural or not. But we were dealing with, the bulk of my day pre-September was dealing with entirely natural causes of death, and basically providing reassurance to GPs and to registrars that it was an acceptable cause of death. But based on nothing really, based on fresh air and instinct. So I do think this is a much better way of doing it. I think the problem is that there was a huge amount of uncertainty, and I think in the short term probably created more work, but I don't know that it does for your GP colleagues really, because instead of talking to the coroner, they're talking to the medical examiner, and it should mean that things are much more straightforward. But there are always those cases where it gets complicated, and I think there can, I know nationally it's been discussed that there is a delay for families in registering deaths, and that is a concern. But my instinct, and maybe it's because I'm an eternal optimist, it will just keep getting better. Again, the medical examiners locally have worked so hard, but they've been completely swamped, frankly. And they would be the first to admit that over Christmas it was a horrible mess, and I'm sure it was all around the country. But we've got through that. We've got through the winter months where the pressures obviously are much higher, and I think it'll give us now, hopefully the summer will give us time just to, really get to grips with it all. And by the time we go into next winter, I'm hoping it'll all be pretty straightforward. So overall, I think it's a good thing. But I don't know that all your colleagues necessarily agree with that, do they?
No, from a GP's point of view, it's so whereas the majority of deaths we could have just filled the MCCD in and send it off. Now for every single death we have to write a report for the ME service, and we have to wait for them to come back to us, and they often phone you. And then some colleagues, particularly in the early times, were the MEs were being a little bit pedantic or picky about what was going on death certificate, because as you've mentioned, the ME often has access to information that the GP doesn't.
Yeah.
And we're working off, and a couple of times I've had that conversation with ME where they're saying, actually, if you look at the medical records in the hospital, it says this, but you've put this on the note, and I say, well, actually, if you look at the discharge summary, what the hospital has told us that the patient has was what I've put on the death certificate. So, and I know that, yeah, over Christmas time, their backlog got at one point up to over 6 weeks. They've got that right back down again now. But talking to Peter, current senior medical examiner, one of the things that he did is he just asked all his ME colleagues to, if the cause of death seemed reasonable, basically not to question it, just to let it go through, which I think has been helpful.
Yeah.
But I think locally we did an awful lot of work in advance, and Peter and yourself and Kathy and we had a funeral director and the registrars also, I think, worked quite well together to actually try and make it as smooth as possible. We had a lot fewer issues or problems, shall we say, than I know that talking to other LMCs in other parts of the country that they had. So I think we actually were much better prepared. But it
I totally agree.
Yeah, it didn't help that some of the guidance didn't come out until the day it was going live.
Yeah,
which meant, yeah. I mean,
it was all quite late in the day, wasn't it? Yeah. I mean, just to mention the senior coroner guidance, although it came out quite late, it is quite helpful actually.
Yeah.
And if you know your colleagues just go on, you just Google the chief coroner's guidance. There's a whole raft of guidance, which you'll not be interested in, but the changes in the death certification certainly is quite helpful. And I think the plan was that there was going to be further guidance issued, but we've not seen anything else since. So I know you and I've been involved in some pretty heated conversations about what an attending practitioner, what the legal definition of that is, and we still haven't got that. But I think there've been some discussions locally and nationally amongst the MEs, and I think where we've got to locally, unless something has happened in the last few days, is that any time in life, face-to-face or remote, and that includes over the telephone.
Yep.
And at one point, I know there was a suggestion from the MEs that should be more limited. I think it was had to be face-to-face. I think there was one point there was a suggestion it wasn't going to be video, but you know, I think where we are now is, and if I'm honest, I think it's up to the GP. If you feel that you are an attending practitioner, then that's good enough for me. But then, you know, a lot of these deaths aren't coming to me now, so it's not really a matter for the coroner, although we have been pulled into some discussions about that, as you're aware, but we're pretty relaxed about it. If you're confident that, you know this patient. I mean, one of the sort of strange quirks of all of this, and I know this is an example that Professor Mason gives all the time, you know, if you see the patient for an ingrown toenail when they're 15, then you can, you know, put yourself forward as an attending practitioner when they die at 85, is my understanding. But you have to be confident that you understand the clinical history and that you can provide a cause of death.
Yeah, I mean, the guidance does include that you should be aware of the patient's last illness.
Yeah.
So, you know, even though the last time you saw them might have been when they were 15, you should have access to the records, access to people who are talking to them. And from a GP's point of view, I mean, we're a lot less involved, particularly with palliative care, end of life, because that tends to be done by the specialist community team. So often our only contact is via third person, you know, by phone with a relative or with the palliative care nurses or district nurses or something like that. And the suggestion, which seemed to actually only come from the Midlands regional ME about the face-to-face, was just as ridiculous, because it meant that, you know, if I'd had a patient that I'd done a 6 weeks check on and they died when they were in their 20s from cancer, I could do the MCSD for them, but not if it was a patient that I'd never seen face to face, but I'd had multiple phone calls about, that had been involved in the specialist palliative care team with district nurses supporting them, done all the prescriptions, written all the authorization for end-of-life drugs. I could have done all that and wouldn't have been able to do the MCCD. So, you know, so what was suggested didn't make sense. Unfortunately, absolutely. Unfortunately, you know, common sense made the day in the end.
I think the only problem is that it's been a big enough change, hasn't it, for GPs without adding to that confusion, and that's the thing that worried me. But you know, I think people are taking a pragmatic view, and certainly we are as coroners, And I think common sense is what it's all about. You know, you're the one that's, if you feel able to offer the cause of death, you know, it almost doesn't matter, does it, to me, if you've been through the notes or whether you've seen the patient, or I think it's, you know, it's got to be you've got to just take a sensible approach, haven't you?
Absolutely. I mean, at the end of the day, you know, you just need to trust the doctor for doing their job. And of course, a doctor is also taking on the accountability if something goes wrong. So it's not that they're doing that sort of in isolation, is it?
Right, exactly.
So I suppose sort of just touching that, you know, from your experience, do you have any sort of tips, advice for GPs to keep themselves out of trouble and out of your court?
Yeah, I think some practical tips really is, well, I suppose feeding into what we've just said, make sure you contact the ME. That's what's required. So don't come straight to the coroner, because the referral will be rejected. It doesn't mean that the referral can't be reinstated. So the way our system works, if the GP makes a referral and we either reject it or we CM1A it, if it comes back to us, the paperwork, I'm told, in terms of what the GP has to do, is relatively straightforward, so it can be sort of brought back to life again on our system. But talk to the GP. The thing I see actually that irritates me a little bit is that we'll get GP referrals and there's a box that says, you know, discussion with ME, and it's very often left blank. So we will then CM1A it as coroners, saying, no, you need to go and talk to the ME, and actually then they come back and say, well, we have spoken to the ME. Well, then you need to fill the box in and tell us, because that would have saved everybody a bit of time. So just be very, I think that the message really is just for doctors just to be very careful about the details in the referral to us. And not only, I mean, what would be helpful to us is not only say, yes, I've spoken to the ME, but just give us a little bit of a description about why the ME and the GP feels it is an appropriate referral to the coroner. I mean, the box at the top of the referral deals with that, but it's about what the ME has said in conjunction with the GP. I mean, we will get that information ultimately from the ME, but very often comes at a later stage, so it saves us really having to make those inquiries. So that's quite important. I think the quality of the referrals, some are really, really good, some are atrocious, and the bad ones actually are the ones that give us nothing. I mean, I am having to make, at the point that referral arrives in my office, a judicial decision about the next stage of the investigation. And that is all I've got, that piece of paper from the GP. So what I need is the story. I need the GP to tell us what the story is. Obviously, the reason for referral, but, you know, the past medical history. I mean, let's say there's a you know, the reason for the referral is a kind of vague suspicion of an industrial disease. If it's a straightforward mesothelioma, then if I'm honest, the cause of death offered, supported by a brief line saying it was confirmed by way of biopsy, is probably enough for me on that day one to make that judicial decision. But if I'm being told, you know, that there were pleural plaques, there's a history that this chap worked with asbestos, but it's all a bit vague, it's really difficult for me to make that next decision. So I need the story. You know, not chapter and verse, but the box is, you know, big enough for you to be able to write in there what the story is, and as I say, the reasons for the referral. So I suppose the quality of the information is quite important. And remember, as I say, that's all I've got. I've no access to the notes. I don't know anything else about the clinical history other than what you're telling me. At that stage, we haven't talked to the family, so we haven't any understanding as to whether they've any care concerns, whether there are any issues that they're raising. So that referral is the first piece of information that I get, and that is the point that I'm making a decision, for example, about whether we need an autopsy or not. Now, if I authorise an autopsy because I've not got sufficient information, the family then object to that and say, well, we don't want an autopsy. Why on earth are you doing that? You know, the GP knows all about this. Again, once the autopsy is on its, you know, the case is authorised and on its way, it's sometimes quite difficult to bring it back. And also it's all, you know, it's all delay, isn't it? It's all time wasted. So give us as much information as you have. What I don't mean by that is swamping me with every clinic letter, and because equally I haven't got time to do that. But what is really helpful is the GP summary. And in fact, our system is set up, I think, that we cannot accept a referral without the GP summary. So if you get stuff thrown back, often it will be because the GP summary isn't attached. So you know, tell us the story, the quality of the referral, the GP summary is really important. I think then the question, I mean, going forward, I suppose the next part of the process is if you're asked to write a report if the case is going to inquest, and that is a whole, you know, I mean, we run training just on that because report writing obviously is an art. And but I think the headlines in respect to that is if you're required by the coroner to write a report if the case is going to inquest, first of all, you'll be given a time frame, and you have to provide really good reasons if you're going to request an extension for that. Normally you're given about 6 weeks. So if you know that for 3 of those weeks you're going to be on holiday, let the coroner know as soon as possible, and the coroner will then almost definitely allow an extension. So you'll be given a period, normally 6 weeks, and the coroner will normally give you an idea as to what is required. You know, detail, if it's a mental health case, for example, you know, what is the mental health history? When did you last see the patient? What medication were they on? Had they been onwardly referred? Had there been an inpatient as far as you're aware at any point? And the key piece of information is often the last time that you had contact with the patient. So the quality of those reports is really, really important. And sometimes actually that will determine whether you're required to give evidence at the inquest or not, because a report well crafted, containing all the right information from a general practitioner, when shared with the other interested parties and agreed as documentary evidence, that will mean that the GP doesn't have to come to court. And I'm sure that's not what any GP wants.
No.
I mean, we're not as scary as they think we are, but it is still an alien environment. You know, they're having to come face to face with the family. It's normally because issues with regards to care have been raised, and it's pretty uncomfortable, I would imagine, for most people coming into, I mean, I always say to doctors, you know, my court is my second home. I'm very comfortable in there, and you probably feel like I do when I'm sitting in your waiting room. It's about being taken out of your comfort zone, and there's sort of implied, I guess, the implied criticism of the care that you provided, even though that may not be the basis for the inquest itself. But it goes back sometimes to that report, because if the report's really good and the family say, okay, well, all the issues have been dealt with in the report, and if there are other interested parties they agree, then I can admit that as documentary evidence at the inquest rather than calling the GP. And different coroners have different views about this, but my view has always been and remains that if I will do anything to avoid pulling a clinician away from their clinical work into my court. That's not what I'm about. If I can deal with it on paper, then that is a much better way of dealing with it. But frankly, if I get a really shoddy report that's not dealt with any of the issues that have been raised, then the doctor's going to have to come, and that there's nothing I can do to avoid that. So it's a sort of process, really, isn't it? You know, the quality of the referral at the beginning, the quality of the report, and then if you are called to give evidence at an inquest, then obviously there needs to be quite a lot of prep involved in that, and, you know, come and familiarise yourself with the court, make sure you understand from the coroner's officer exactly what the issues are. I know that the medical defence unit is often very good at providing support and sometimes advocacy at inquests. And talk to your colleagues. That's the other thing. If you know somebody who has been to an inquest and you haven't, then seek them out and talk to them, because you know, they can give you, I'm sure, tips on how to present yourself at the inquest and the quality of the evidence that you give.
Okay, that's helpful. I mean, fortunately, in my career, I've only been to a coroner's court once, which was about 30 years ago.
And how was it?
It was really stressful. The coroner was I think past retirement age then, but he very kindly, I didn't realise the time he gave me was an hour in front of when the actual hearing was, so he could come and meet me and show me around and familiarise myself. And the reason why he said he had to call me, because although I'd done what he said was a quite reasonable report, and he himself looking at it didn't think there was a problem. He said the problem was that the family still felt that I was at fault for the death of their very elderly relative. But it was, it was really stressful.
And that's the problem, actually. In those circumstances, the coroner's hands are tied, because the only way that you can admit documentary evidence is if the interested parties, and of course the family are always an interested party, agree to that. So sometimes the coroner actually is desperate not to have the doctor there and have it as documentary evidence, but if the family don't agree.
I mean, one of the things I found strange is that the family were represented by I think a barrister. But the coroner also gave the family an opportunity to sort of cross-examine me as well, which obviously it wouldn't happen in a normal court. I found that actually even more stressful.
Yeah. Well, the two things. First of all, the phrase cross-examining, although I'm sure that's how it feels when you're sitting in the witness box, there is no cross-examination allowed in the coroner's court. It's a fact-finding inquiry. It's very different to the other courts. The coroner, of course, is not only involved in the investigation, but then makes a decision about exactly which witnesses are required and the form that the inquest will take. So you'll be aware, Grant, that if a doctor comes to court, when they come into the witness box, the coroner will ask all the questions that are relevant in terms of the statutory questions that I have to answer. But you're right, if the interested parties are legally represented, it's the legal representatives who ask the questions. Now, it's a bit of a double-edged sword. Sometimes when families contact us and say they've instructed solicitors, and it's pretty rare because there's no legal aid available in the coroner's court, so they'd have to privately fund that. If there's a civil claim running alongside, then sometimes the lawyers will piggyback. They'll come and represent families at an inquest, in effect free of charge, in the hope that there will be compensation in due course and therefore the costs will be covered. But so it's rare to have lawyers representing families. But sometimes it's music to our ears, actually, because the problem with a lot of families is they have, no, not a lot of families, the problem with some families, and actually they're few and far between, but they have completely unrealistic expectations, not only about the clinical care, but also then about what I can do in terms of my process to deal with that clinic, that what they see as an omission in the clinical care. So when they say, well, we've instructed lawyers, you sort of breathe a sigh of relief and think, well, great, because they'll be sensible and pragmatic and measured about it. But not always the case, because some lawyers can make things very tricky in court as well. And I suspect, without speaking out of turn, that some feel that they have to justify the fee that they're being paid. So they perhaps ask questions in a manner that isn't acceptable in the coroner's court and ask questions that are outside scope. The coroner's job then is to keep reining them in, to keep explaining, whether it's an unrepresented family or a lawyer, no, this is the scope of my inquiry. It's non-adversarial, it's fact-finding. This doctor is not on trial, cross-examination is not required, not only not required, but not tolerated. But all the time, the poor doctor is standing or sitting in the witness box thinking, this is the most uncomfortable thing I've ever had to go through in my life. I understand and accept that it's difficult. And actually, we talk, again, locally and nationally about the impact of coronial investigations on families, particularly those investigations that are delayed for whatever reason, legitimately delayed. And the terrible emotional impact on families. But what is forgotten, I think, a lot of the time is the emotional impact on the witnesses as well, and particularly clinical staff. I mean, I've had very senior consultants in the witness box in court, not in this jurisdiction, really, really visibly upset and distressed because they've had to wait months for an inquest. And then at the inquest, they've got a family who is really distressed and quite aggressive with them, and they feel that they've done their absolute best, and it's traumatizing. But that is the system that we have, and overall, I think it's a really good system, actually. I would say that because I'm a coroner, but I think it is really good. And I think in the end, if you've got a good coroner who manages it well in court, it can be really cathartic for clinical staff and for family alike. And again, that very same inquest, at the end of the inquest, I had everybody, I mean, I didn't instigate it, but everybody spontaneously was hugging at the back of court. You know, there was that sort of lovely coming together. But the process was horrendous for everybody. Yeah. So it's difficult. I understand that. And I think, you know, most coroners are sympathetic to the fact that it's tough when you have to come and give evidence here. But it is required, and you know the law is very strict. You know, I say this a lot to families. I don't pick and choose which cases I investigate, which I inquest. It's all laid down within the legislation. So there's a very sort of set process that we have to go through.
Okay, that's been extremely helpful. Is there anything else that you wanted to add?
No, not really, except I think it's great that, you know, certainly within Leicestershire, we have such a good relationship with all our stakeholders, and we can continue to do this kind of thing. I mean, we are pretty approachable here. And I think, you know, just to put the message out that if anybody's got any questions, if anybody wants to come and sit at the back of an inquest, you know, because they're nervous about having to give evidence in the future, just get in touch with us. You know, we're always very happy to talk to people about what we do here, and you know, our doors, well, they're not open, we sit behind locked doors, but you know what I mean. I mean, if you contact us, we're very happy to accommodate you and accommodate any questions that you have.
Okay, so thank you, Louise Pinder, HM Senior Coroner for Rutland and North Leicestershire.
Thanks, Grant. Thank you.